What were the rules of Roman inheritance law? Imagine inheriting a family estate in ancient Rome. How was it decided who got what? The Roman inheritance rules were carefully structured to keep property within the family and uphold social order. In Rome, when someone died, their property could be passed on through a will or by law if no will existed. The law was strict to prevent disputes and fraud. The primary heirs were called heredes sui, meaning those under the deceased legal power or potestas. These were usually children or descendants still under the authority of the paterfamilias. They inherited equally and through a system called stirpes, which meant inheritance was divided by family branches, not individuals. If there were no heredes sui, inheritance went to relatives in the male line, called agnates. These were close male relatives like brothers or nephews. If no agnates existed, the estate moved outward to the gens, or clan, and then to cognates, relatives through the female line, within 6 degrees of kinship. Widows had limited rights initially. They were considered part of their father's family, not their husband's. But later laws granted widows some inheritance rights, especially if they had children with the deceased. Usually, widows could only inherit after closer heirs were taken care of, and they often received a life interest called usufructus, meaning they could use the property but not own it outright. People could leave a will, called a testamentum. Wills were written on 3 wooden tablets covered with wax, sealed to prevent tampering. The testator named heirs and specified how property should be divided. The Senatus Consultum Neronianum of Ad 61 standardized the form of wills. If a valid will existed, the named heres took over the estate completely. If not, the estate followed the rules of intestate succession. In intestate cases, the estate first went to children and their descendants, including adopted children. Grandchildren could inherit only if their parent was no longer under the deceased power, like if they had been emancipated or had died. If no children or descendants were around, the estate moved to agnates, then to more distant relatives. Widows could inherit only after all closer heirs were exhausted and usually received a share called usufructus. Later on, Emperor Justinian reformed inheritance laws in the 6th century after Christ. He removed distinctions between male and female lines and prioritized descendants first. If none were available, the estate went to ascendants and siblings, then to more distant relatives. Widows received a quarter of the estate if they were poor or shared equally if there were more than 3 children. Debts of the estate had to be paid before distributing the remaining property to heirs. Any property given during the lifetime of the deceased, like dowries, was deducted from the heir's share. Roman inheritance law was designed to keep property within the family and support social stability. It reinforced the authority of the paterfamilias and made sure wealth stayed in the bloodline. Wills allowed people to control their property, but strict formal rules protected against fraud. The system balanced the interests of children, relatives, and spouses, reflecting Roman values of family and social order.